3, 2, 1, start. If the suit is filed for fixing boundaries by the court, then appointment of advocate commissioner would serve purpose to decide the real controversy between the parties, but it is not even the case of the petitioner that scheduled property is not demarcated. In such case, appointment of advocate commissioner is wholly unnecessary and it is beyond the scope of the suit. The trial court did not look into the reliefs claimed in the suit plea of the petitioner regarding survey of land and fixation of boundary stones and the purpose for which commissioner is sought to be appointed. In those circumstances, the order passed by the trial court cannot be sustained as it amounts to grant pre-trial degree in view of the law declared in Muhammad Mehtab Khan first Supra, and it is therefore liable to be set aside. Accordingly, the appointment is answered in favor of the respondents and against the petitioner. Under Section 14 of Indian Post Office Act 1898 and under Section 16 of Evidence Act 1872, when a registered letter is sent to a person and when it is returned by postman with the endorsement absent, the endorsement made on the registered cover is a prima facie evidence of taking the said letter to the address of the person noted on the registered cover and that the notice thereon is prima facie proof of absence of addresses. See para 32 and 41. Presumption as to service of registered letter in view of provisions of section 114 illustration F of Evidence Act 1872 and section 27 of General Clause Act 1897. There is a presumption that the addressee has received the letter sent by registered post. A close analysis of legal position in plethora of decisions referred above makes it clear that if the defect in election petition is curable, an opportunity shall be given to cure defect. If failed to cure, the petition shall be dismissed as per Order 7, Rule 11, or strike out the pleadings as per Order 6, Rule 16 of CPC. The defect of non-joinder of other candidate is incurable defect even otherwise the petition filed by the first respondent oblique election petition under Order 1 Rule 10 of CPC was dismissed by the tribunal and the same was confirmed by this court in CRP number 5024 of 2014 dated 30th 12/2014 and attained finally. Therefore, by applying law declared by various courts referred above, this court has no option except to reject the contention of first respondent oblique election petitioner, holding that the election petition is not maintainable for non-compliance with section 72 read with 74B of the Act. As the tribunal has merely followed the law laid down by the Supreme Court in M. Nagaraj 1 in allowing the O.S. the orders of the tribunal to the extent it declared the action of the railways in providing reservation in promotion without fulfilling the parameters laid down in M. Nagaraj 1 to be illegal do not necessitate interference. The Act, however, remains that despite the amendment to be constituted by insertion of Articles 16 within bracket 4A and 4B nearly 14 years ago, the members of the scheduled castes and scheduled tribes still face uncertainty on whether or not they are entitled for reservation in promotion and to be extended the benefit of consequential seniority. This predicament they find themselves in is for no fault of theirs but is on account of the failure of the Union of India to gather data and form its opinion on the parameters laid down by the Supreme Court in M. Nagaraj 1. The prevailing uncertainty and only be put an end to if the petitioner railway is directed to undertake the aforesaid exercise and take a decision within a specified time frame.